My name is Adrian. I'm a partner at CMS. We are here today to talk about bonds in the context, or arbitration in the context of bonds, bonds in the context of arbitration. It's pretty rare that you have a construction project, at least a complex construction project, particularly in this region where bonds don't come into play. So we thought it was a good topic to talk about. We wanted to talk about construction. Obviously, given it's the Arbitration Week, we wanted to talk about bonds in the context of arbitration. We set up today a panel for you to talk about various aspects of the subject matter. First of all, I wanted to thank Horizons for hosting us. I think you'll agree it's an amazing venue. I'm told that the pace will lift in a minute and the view will get even better, but hopefully that won't be too much of a distraction to you, and you'll be able to focus on the discussion instead. We've got about an hour today to talk about these topics. I'm going to try and leave some time at the end for questions and answers. So if you could leave your questions until the end, just to make sure that conversation flows freely in the meantime. Just to introduce my panelists, I'll start from the end. I've got Waeel. He's legal advisor at DEWA. He's got a master's degree in commercial law. He's been at DEWA since 2014. So he's coming to this topic really from the perspective of looking at bonds from an employer's point of view. He advises on all aspects of DEWA's work, both on front-end transactional work and also on disputes. Next to him, we have Alfredo Yañez. Alfredo and I met over 10 years ago working on a EPC dispute in Qatar. Alfredo is head of contract management for Middle East and Southeast Asia for Acciona, so he's looking at this from an EPC contractor's point of view from the supply chain. He's been in Dubai for a long time now. He looks over a portfolio with a value of over 2.5 billion across his region. I don't think our next panelist needs much introduction. For those of you that don't know him already, Mr. Ali Zarooni, he's managing partner of Horizon, founded Horizon. He's a very, very well-known lawyer in the region. He's looking at this from an advocate's perspective. I think one thing that may come out of the discussion today is if you're dealing with bonds in the region, it's very helpful, if not essential, to have local advocates involved who have good connections with the courts to make sure things flow freely. So Mr. Ali is looking at from that perspective. And finally, nearest to me is Greg Sibbald. Greg is a partner of mine at CMS. Greg heads the team in Dubai. He's very experienced in construction work before joining CMS. He was with Clyde & Co in the region. CMS, so he's coming back to us, which is nice to see. He's been in the region nearly 7 years, so he's looking at it again from a lawyer's perspective, but maybe just a bit more of a sort of international perspective. So we're going to move on. As I said, we've got a number of topics we're going to talk about today, and we're going to try and give each of the panelists equal time. So we're going to move between them a bit, but it is intended to be sort of fairly free-flowing and it's not scripted. So forgive us if we move around.
Despite the script.
We've got a list of issues, but not any words to them. So yeah, it may kind of move around a bit, but hopefully that's part of the fun and keep the interest levels alive. So one thing we were going to kick off to talk about, and I was going to ask Alfredo to talk about this first of all, is what type of bonds do we see typically placed in the region, Alfredo?
Well, thank you, Adrian. Thank you, everybody, those who are here in the room and those who are remotely connected. Although all of you are familiar with the issue, as a matter of introduction, I would say the more typical bond would be a performance bond, followed by, let's say, defense liability bond in those instances where the performance bond is to be replaced or returned to the client at the end of the construction and before the end of the defense liability period. Also, since the majority of the projects in the region have advance payment provisions, that will require an advance payment bond. And then, even though, in my experience, most of the employers' standard contract forms require in-cash retention, it is fair to say that those employers are accepting more and more to exchange this retention in cash provision with a performance bond to ease the contractor's cash flow. So I would say that having retention bond provisions is also frequent in the region. In terms of conditions of this bond, the reality is that the trend is that all the bonds are unconditional on-demand bonds, and you need to check on the requirements in the contract that allows encashing those bonds. Although, as we may touch later on, those requirements are not always respected by the party holding the bond. I don't know, Greg, you have?
Yeah, no, that's similar. Yeah, Alfredo, that's the sort of bonds that I see from a lawyer's perspective. And I guess the main point is they're I guess, exclusively on-demand bonds. And in certain instances, there will be conditions in the contract which will set out when those bonds can and cannot be called. But we certainly see plenty of contracts where there's no such conditions, which obviously leaves contractors sort of fairly vulnerable to these bonds that could just be sort of called at any time by the employer.
If I may add, from a contractor's perspective, I would say that also the trend is that contractors will like to have similar provisions on their downstream contracts, on the supply chain contract, and asking for similar types of bonds. Although in this region, as a difference with other regions I've worked with the smaller companies, they're still reluctant or they may not have access to bonding facilities, and they sometimes provide guarantees in post-dated checks and the like, which is something which is quite typical from this region, and I'm not seeing elsewhere. But I would say that the trend is that from our perspective, we are now only accepting this for very, very small contract value, because the risk of being exposed with this type of security is getting higher as with the time. You know, in the past, I think post-dated checks were easier to pursue. Nowadays, it's becoming a little more difficult, at least in our experience.
That's right. Yeah, I think that's interesting, obviously, to hear about the type of bonds that are typically in place in the region and the conditions. But from an EPC contractor's perspective, I guess Alfredo, the biggest fear is when the bond is called, and that's when we do all the scurrying around, rushing around, involving people like Mr. Ali. Well, often we involve them beforehand, and we suspect that the bond might be called. But what type of circumstances do you typically see bonds being called?
Well, I would say that with the years, at least my personal experience is that we're moving into a more, let's say, sensible approach to calling on the bonds. When I first arrived to the region, as you say, Adrian, more than 15 years ago, the trend was that employers will use cashing the bonds just to gain leverage in whatever type of negotiating situation you may face. So it was quite frequent to be at risk, or in situations where the employer just, even though the contract will not allow, or the conditions in the contract will not be made, they will just cash the bonds at the first recourse when there was a serious threat of dispute. I would say that in the recent years, that has somehow moved to a more sensible approach. And unless you as a contractor really screw it up by, let's say, abandoning the works or repudiating the contract or something like that, they are somehow reluctant to cash on the bond. I would not say this is not happening, because in the last years I had some experience where I see bonds being cashed or attempted to be cashed. But it was, as I say, in situations where the relationship between the parties was already broke, and where the contractor has failed in every single attempt to make good their default or the defect, just ignore whatever request from the employer and given the employer in those circumstances. I don't know if anybody else have different.
Obviously, as I said, it's interesting to hear from the contractor's point of view. But Waeel, what about from the employer's perspective? Have you seen that shift becoming more pragmatic, and what do you think accounts for that, really?
First, just I want to add that I want just to go back to the first point, that we have also one of the type of bonds. We have the bid bond or the tender bond,
Yeah.
just for the like for us, like just like an employer, just when we launch a tender, so there is a tender bond. They have to all the bidders, they have to submit it, which is just about 2% to 5% of the tender. Then also this is one of the bonds which may be called also, if you just like you as a winner bidder, and then in the end you fail to complete or to sign the contract, then this may be called also. This is as per the law. We are applying this now, law number 12, 2020, regarding this is it's a Dubai government law. It's regarding the contracts and warehouses of management in the government of Dubai. So it's per the law.
That is a really bad start.
No, but this is as per the law, but what is going is different actually. We are just as in our management in the DEWA, they have just a very wide, just like they are very flexible in the things. And also, as per the law, there is sometimes also there's like exemptions from submitting this bids also. It's also for even the performance bond. Also sometimes with
Alfredo will be very interesting.
Yeah. So calling the bond, it's be maybe just the last option for the employer if there is a lot of other options. Even in the law give like certain cases, like also can just like if there is a delay, you can impose the penalty. If there is and negotiation also, just like to just we don't want to reach to this stage. You know, it's maybe just this like for the contractor, it's like disaster if just like you call the bond or like this. But for the employer also, you want the project or the work to be done as specified in the contract. So it will be like let us see it from the other side. It will be like you are give another chance for your project to complete. Yeah, sometimes calling the bonds is just like if I'm going, there is another option. If the contractor failed to just like to or delayed in his work, so you can appoint another contractor. So it'll be a difference in price. So when you call the bond, just at least you can just cover the difference. This is the for us it will be just like mitigating the loss and like this.
Yeah, I do agree. That's exactly what I'm seeing, that the employers are taking a more sensible approach as to if they have a real actual damage, they use the bond as a facility to cover that damage rather than the approach they took years ago, that the bond was just a leveraging tool in their hands. And again, I appreciate that this has made contractors' lives easier, because in situations where you're negotiating or you're fighting for your rights, I mean, you come to the table in a more balanced position rather than with a knife in your head that take it or leave it, because otherwise I'll kill you. I mean, essentially here the problem is that depending on the size of the companies, calling on the bond can be very, very serious, because especially the middle to lower size companies, they can only have access to bonding facilities, so they keep assets freezing in their accounts. So essentially calling on the bond will really damage them. And I think this is something the employers are appreciating and trying to make our life a little bit easier.
If I would interject on this, because I saw this very nice question. Is it just justified or unjustified? And that is a really questions. It depends on what's the contractor see it, what the employer always. And unfortunately, we keep both of them. So we should give them,
but we are not fighting.
Right?
So.
But that is always justified or not justified, as both of them, the panel speaker here, they rightly said. It's always depending on from where you are coming. So if a contractor always seeing that we are done job more than the bonds, so why you guys calling the bonds? You are putting us on a difficult position. Employer said, no, we need the project to go in a smooth way. So it's always very, very debatable question, actually. Sorry.
Also, I was going to add in, I guess that's sort of is a sort of reality of construction disputes, because you rarely get a construction dispute where it's just one party is in the right and the other party's completely in the wrong. The answer normally is somewhere in the middle. So I guess the contractor and the employer will both sort of have strong positions as to why the bond should or shouldn't be called. But yeah, the answer is probably somewhere in the middle as to whether it was right to do so.
Well, I think it's always good to start the morning with some happy news. It's happy news that bonds don't seem to be being called as much, or at least not in a kind of troublesome way where people are doing it for strategic reasons. But we still see them being called a lot. And I think, Alfredo, if you just started touching on one of the topics I thought would be interesting to explore in a bit more detail. You talked about the impact it could have on some companies, but what about on the project itself? If you look further down the supply chain, what impact can calling these bonds have?
Well, again, the approach has evolved. Years ago, the first thing I will do as a contractor, if my employer called my bond, was to go down the supply chain and call every single bond to just get as neutral as possible. But in reality, I mean, everybody will be aware that this only aggravates the problem, and it's like a snowball rolling through the mountain and getting bigger and bigger and bigger. So I think the approach we're just taking is that if we get our call bond, well, in addition to, let's say, defend our rights and try to alleviate the situation, is just look for the parties who may have been in the supply chain responsible or ultimately responsible for that upstream bond being called, and of course call their bonds, but not every single company in our supply chain, just those who have relations or maybe responsible for whatever default I have committed. And the reason for that is, as I said, fortunately, we are a big international company and have access to bonding facilities in, let's say, a more Western way, where we don't have cash securities behind our bonds. But local companies, which are the ones that we use in our supply chain, they are not in a similar position. And if we just go unreasonably calling every single bond in our subcontractors, some of these companies may not be able to survive or to resist, because they will be under extreme financial pressure, and then we'll be in trouble. And ultimately, regardless of your dispute, what you want to do is get your job done. So it's not very clever to kill every single subcontractor if your ultimate aim is to get your job done.
Having said that, there will be circumstances where legitimately you can and you should call these bonds.
Yeah, as I said, indeed, recently we've done that. We have an instance where a situation with one of our subcontractors, which was causing a problem upstream, and we asked them to remedy the problem. He didn't observe. We pushed him. We negotiated, tried to find civil situation, and what was clear that they were not going to react, and they have abandoned the job, as similar to what he has said. We have no option than to find somebody else to do and to cover, and then our only remedy to call on the subcontractor's bond to recover or to mitigate our losses and to be able to cash this additional work. So I'm not saying we are not calling. I'm just saying we are taking a more sensible approach as to which ones we call, rather than calling every single bond.
Effectively, you're replicating the approach the employers take to you. You're being more pragmatic about it, as well than just calling them in the same way you may have done previously. But what about you from an employer's perspective? What impact are you seeing bonds can have on these projects?
Actually, to be honest, it's just like calling the bonds that should be in the last stage, if there is no other option. Okay, because it's just also for us, for example, we're just doing very sensitive projects. To be the projects will be as a government entity. We are just doing for the for the government of Dubai and doing this. Yeah, we are the only entity who just providing the electricity around Dubai. So we have to be all the projects should be on time. So this is also just cause for us a lot of problems. So that's why we have to be just very strict with just like time completion and like this. So just as per like, for example, we don't go for just like this process. Just we have a lot of negotiation. We give a lot of extension of time. We give a lot of things, but sometimes the contractor just like failed in every options you give it. They are in the end. No progress. What you will do, you have no other option, and then this you have to you have other also this will cause a lot of problems. Even for we have like we can say like time we have to finish within that time. So this is very important for us, and it will cause for us a lot of like issues. So that we have to solve it in this way. Otherwise, sometimes also, if you just like, does not mean that when you call the bond that you terminate the contract. Sometimes contracts may continue, just like to, at least you have to just reduce the losses and like this. And just even the law is giving us in such situations a very wide, just like solutions. And one of them, this calling the bonds, but we don't usually prefer to go for this unless we reach to the end. This is the idea.
Okay, so I think that probably brings to an end the first part of the session where we wanted to give a bit more background to bonds, the type of bonds, where they would commonly be called. Now we're going to shift gears and we're going to look a bit more at disputes, because as I said at the beginning, it's by arbitration, which is quite clear. Obviously, from a EPC contractor's perspective, further down the supply chain, if you get wind of the fact that bond is about to be called, then, as I said at the beginning, there's a lot of rushing around trying to do what you can to prevent the bond being called, because we've heard from the speakers what consequences it can have on the projects and the companies themselves. So next, I'm just going to ask Mr. Ali to outline in some detail what measures could a company take in the UAE local courts to try and prevent the call on the bond.
Thank you, first of all. Thank you for all our audience here. Of course, I hear lots of good movement for the contractor and the employer that they are not cashing, which is make our business less, but no problem. As everybody is working on construction, always the most important thing is how to speed to prevent the employer to encash the bond and the main contractor to encash the subcontractor bonds. That's always the situation. Now, the famous thing is to do the precautionary attachments. Here there is everybody's talking about precautionary attachments. Precautionary attachments always, which I notice it on practitioners actually, they are doing a mix of confusion between a normal precautionary attachments and an attachments over the bond, and this is a very big difference on how to apply it by the law, because the bond here, since we are talking only the bond here, it says the requirement and the law, which is you need to base your ground, is different than the normal precautionary attachment. So you are attaching the bond, then you need to apply a commercial law, not a civil law. People, they are doing actually mix of both. This is the wrong thing. And always when we have the urgency, people, they said we need to show that there is a high risk and there is a risk for us to lose our money, then we need to do that. Is not required on the bond. People, they said, how that's happened. This is the right reading of the commercial law, where the bond freezing is coming under that. So always on the bond calls, which is attachments, you need to do attachments on the bond calls. Always you need to be showing one main thing, which is the serious disputes. Now, the serious disputes, I think if you are in-house with a contractor, you need to show and you need to document the serious or disputes on the reason why they are trying to threaten. So you need to demonstrate, you need to show the judge that there is a serious difference between us and employer, and show that they are not actually sensible employer to listen to us. And we did, despite we show a lot of progress on the project. So,
and that would be a dispute on that would be an underlying dispute. So say we're talking about liquidated damages, it would be that the contractor legitimately challenges the application of liquidated damages, not a dispute on the application of the bond itself.
Yes, of course. And this is what this is always coming before the bond has been called. So you need to demonstrate all of these arguments, because the judge, you need to sense it from the documents, because as everybody knows, the arbitration, if you have arbitration clause, which is most of the contractor contract or construction contracts has, always now we need to apply it to the appeal court. Appeal court, this is an application in the absence of the parties. You have no hearing, you can explain. That is why the documents is more important today, to show the judge the serious of the disputes, and you'll have a legitimate reason why you are asking to freeze it. If you don't have that, then it will be difficult for the judge to give you the decision. And that is why we need to prepare it before. This is unfortunate. A lot of contractor, they are actually not ready. I'm not talking about you. So always we need to be prepared and ready. And I think in my reading also to even arbitration law, there is also a different applications which actually has not been tested on Dubai court. Maybe Greg can talk more about it on arbitration, because there is clauses in arbitration law can allow you to apply for an interim measure, not to freeze, but to order the contract or the employer not to encash. So refraining to do something, which is not actually the practice on the Dubai court. I don't see any reason why the Dubai court cannot use that articles, but I think most of the practitioners, they are just going for the precautionary attachments, not thinking on the other, because it's not regular. In arbitration, I did experience, maybe I'll leave this to Greg to talk about it more. Please go ahead, Greg.
Oh yeah, no, thank you. Yeah, no, yeah, I guess that's a sort of an important distinction between arbitration and local courts, and certainly my experience also is that the sort of first remedy, the most sort of popular and common one, is seeking a precautionary attachment in the local courts. And I guess just to clarify what the application, at least in my experience, is, it's an application for an order against the bank to stop the bank drawing down the funds and releasing it to the employer as an or the contractor that's called the bond, as opposed to an order against the employer or contractor to withdraw the bond. And we'll probably, I think we'll go into the discussion on arbitration in a bit more detail later on, but that's probably quite an important difference between the two remedies. But I think what you're saying is that the local court also offers that remedy of asking the employer or the party who's called the bond to withdraw the bond. So you can, I guess in theory, you could probably make an application against the bank and the employer at the same time.
Yeah, we do that as a tactic also to bring the employer, so they will refrain to do that usually. But always the court tell us why you are bringing the bank on the picture, because you don't have a contract with the bank. The contract is between the bank and their client, which is a contractor. So it's you are out of that contract. So sometimes it's happened this way, yes. Yeah. But we do it always. We try to bring all of them at the one.
And the one, yes. And I guess also the point you made initially about the sort of, I guess, lack of understanding between the civil rules and the commercial rules. Yeah, that certainly has been our experience also, because I think initially when parties were applying to seek an attachment to prevent a bond call. They thought there was sort of these two important parts, sort of two tests. The first was demonstrating the serious dispute, and then the second was demonstrating that if this attachment wasn't granted, the funds that would then be transferred to the employer are going to be dissipated, or the employer is going to become insolvent. And I think a lot of parties thought that that was a real hurdle to try and get over. I think what you're saying is that's not really the issue. It's more about demonstrating the serious dispute. And that's kind of in line with a case we had a few years ago where it was actually a precautionary attachment we were applying for, where EMAR had called the bond, and there was a serious dispute between the contractor and EMAR, and you'd always assume, well, EMAR's not an entity that's really going to go bust or dissipate assets or flee the country. So that was the big concern, but the court's focus was very much on what's the dispute here? Is it a serious dispute? What's the status of the works? And the court granted the attachment on that basis.
Sure.
So like my experience is certainly like
it is always, it's depend on whose bond has been called. So if the main contractor called the bond of subcontractor can play in a different way by showing that the main contractor actually facing financial difficulties. That's the reason they are trying to do it. And we did do it with some companies now under liquidation. So always we try to show the judge that the main contractor is actually unjustifying why they want to call the bond, but we can show the court that he actually calling the bond because he has a financial issue. So he is actually financing his project on our shoulders while we don't have what Alfredo rightly said. Not all the subcontractor was the reason for the delay. So why you are calling me my bonds and not, for example, MEP? But I'm not an MEP. So always you need to show this all documents. The judges need to see this. The problem of people, they don't actually prepare themselves earlier, and that is the really a big issue we have here.
Yeah.
We've heard a lot about attachments and the different options, but is it worth just spending a bit more, maybe a few minutes, talking about the advantages and disadvantages of applying for attachments in the local courts?
Sure. I think the advantage is, of course, very obvious. That's to stop the bleeding of the money, because that is the big issues. All contractors, they face it because they usually in a major disputes, always the contractor always actually ahead on their progress, but for a different reason they are not being certified for a reason or other. So end of the day, they feel that they did the job more than what's they actually deserve to receive. So always that. So precautionary attachments always good to stop that. It's good to give a fairness to the parties, because usually, unlike DEWA maybe because they are a government, but the normal employer always try to put a pressure over the contractor, and which is unfair. And we in our practice over 25 years now, we saw sad stories about this calling the bonds and everything, because it's really show that the contractor the employer tried to put a pressure. So always that is give a better fairness, because then it will allow the both party to debate whether in arbitration or in the court. Then they can actually justify who is mistaking and what. The advantage also that the court is quicker, because if you look at all the interim measure, it's allowed even in arbitration. But I think in the practice still now, emergency arbitrator, or it is with even if you are in front of the tribunal, constituted tribunals, the decision is late, taking more time. In the courts, in a maximum between 24 to 48 hours, you get an order, then you can immediately through their communication or contact of the courts to all the banks and others, in about 1 hour, everything is will be freeze. So that is a given advantage why you are going to the court, not to others. And I think some of the matters which we also dealt, and just for as an info for everybody here, even when we have sometime when jurisdiction on DIFC, I think they are very also quick, and they fix a hearing with a judge quickly. The way they are doing in DIFC, I actually like it because it gives you a chance to explain to the judge why you want a freezing order. It's a nice, sensible way. Yes, it is a little bit tough because the judge will be very, tough with you to ask you a justification, which we did use it, but I think so. The speed is the most important. Now, you said about the disadvantage. I don't see it. There is a lot of disadvantage because you exercising actually your rights to freeze your bond. If you did succeed, that is good. If you did not, that doesn't mean that you are not entitled, but the judge, based on the documents in front of him, he finds that you are, he doesn't feel that there is enough reasoning for him to order the freeze.
I guess one disadvantage would be that there's a requirement, isn't there, to start substantive proceedings within a fairly short time limit afterwards.
That's good. That's also another, there is some misunderstanding here. If you have a precautionary attachments and normal, not on the bond, you have to do it within 8 days. But if you are in the bond, the commercial law is not mandatory required to file as a substantive case within 8 days. This is a lot of people, they get mixed, and that's why I said it.
Oh, sorry, can I ask a question? Is that for any type of bond or only performance bond?
No, all the type of bonds.
Okay, so
As long as it's a bond, whether it's a performance or it is a advanced bonds, always you are not required to file the substantive case within 8 days. The people, they make a mix. That's the issue. Yes.
Yeah, I guess just to sort of pick up on a couple of the sort of pros and cons from my perspective and experience. Yeah, I totally agree in terms of the speed of the process. The local courts can be quick with these types of applications. Although what we do tend to find, particularly where we're dealing with maybe international contractors, the POA is the big issue. So obviously for a local court application, you always have to have the POA in place, and it's quite common. Well, for example, if there is no POA in place and there's no one here in the UAE with authority to grant that POA, there is this hurdle of trying to get a POA from the UK or Spain or another country.
Just to clarify, power of attorney you're talking about.
Power of attorney, sorry, power of attorney, yeah. So there can sometimes be that sort of hurdle of getting the power of attorney in place in enough time to give sort of Mr. Ali, the local advocate, the sort of authority they need to go to the local court. So from a timing perspective, that can cause an issue. But I think once you've sort of got all of your ducks in a row, I guess, so to speak, the process does move quickly in my experience as well. And then and I guess like that's a disadvantage, but I guess just in terms of like other advantages, and we'll obviously go on to talk about arbitration in a bit more detail, but I think the courts here, it maybe wasn't the case a few years ago. I think now they're very well versed in dealing with these types of applications. Because Alfredo and Waeel spoke about the sort of, I guess, slowing down of bond calls in the region. We probably see the instances where they are called quite often. So I think in recent years it seems like the courts they're sort of very well versed in dealing with these types of applications, although when they shouldn't be granted. So that's also sort of another benefit of the whole process.
So we've heard a lot about sort of the local courts. I think it's been really helpful to sort of set out that process. And Mr. Ali touched on arbitration. I guess if sort of most of us, or at least those probably that don't deal with it on a day-to-day basis, think about arbitration, we associate it with being, you know, a very long process and often a very expensive process. So how, Greg, could it actually help with bond calls? Surely you're waiting a couple of years for a decision.
Yeah,
how's that going to help?
Well, I guess there's kind of two scenarios. So the first is if you already have an arbitration that's kind of up and running. So there's other disputes in the project, that arbitration's underway. There will be interim powers available to the tribunal to make certain orders against the employer if the employer is called to the bond. Those powers are in arbitration law here. Most sort of institutional rules will have will set out the sort of interim powers that are available to the tribunal. So you can, as part of that process, make an application, ask for the tribunal to determine the issue quickly, and hopefully that resolves the issue. I guess the sort of major flaw in that process is that the tribunal really only has the power to make orders against the party calling the bond, not the banks. The bank probably won't be a party to the arbitration. That's when you have the sort of ongoing arbitration. The other option is, if the arbitration hasn't started, you can potentially seek, and I think Mr. Ali referred to this, apply for an emergency arbitrator to be appointed. The DEWA rules, I guess the new rules that came in this year, has now introduced the power to appoint an emergency arbitrator, which is obviously quite refreshing for the region. I guess though, just the sort of practicalities of that and the timing of that, it's probably a little bit sort of back to front with what we described with local courts. I think the process to kick off the procedure is potentially a bit quicker because you won't need the power of attorney. You can just immediately file the application. So you can probably get into the process a bit quicker, but then I think once the process begins, there probably still will be a day or two before the emergency arbitrator is appointed. The emergency arbitrator probably would want to, I suspect, would be reluctant to make a decision sort of ex parte, would want to hear from both parties, so may fix a kind of short hearing. So there is a bit of time for all of that to happen. And when you do have a bond call, timing, as you know, is very, very limited. There can only sometimes between the time from the point that the bond's called until the bank releases the money, there can only be sort of 3 or 4 days, the sort of maximum. So that's, I guess, the two sort of options in the context of arbitration.
The problem you identified with an ongoing arbitration applies equally to an emergency arbitration, that the bank's not normally a party to the arbitration agreement.
Yeah.
So what you would be doing in those circumstances is presumably seeking an order from the emergency arbitrator or the tribunal if the arbitration is ongoing, that the employer should withdraw its demand.
Yeah.
Is that how you go about it?
Yeah, I think that's generally how you would go about it. Yeah, as you said, the tribunal would not normally have power or jurisdiction, I guess, over the bank to order the bank to not withdraw down the funds. So yeah, the order you would be seeking would be requesting that the employer withdraws the bond. The sort of, I guess, like the kind of obvious difficulty with that is the employer, on the back of a tribunal order, that's not an enforceable order on the face of it. So the employer may choose not to do it. Although I think if it's in the context of an arbitration, it would probably be quite a sort of, I guess, stupid employer not to follow the tribunal's order, because obviously in the arbitration there are a lot of bigger issues at play, and what parties are trying to do is just present themselves as reasonably as possible, as being sort of reasonable parties. So if the tribunal makes the order, okay, it might not be sort of, I guess, enforceable like a court judgment or court order would be, but there's a kind of there's a bigger picture at play. So
Sure. If I add to or complement what Greg said, the tribunals or the emergency, so it's always depending on where you are from your process of, if you are in arbitration. So if you already the panel has been already constituted, then you can apply it to them. That could be good, but the problem always, when till you constitute the arbitral tribunals, that's take time.
Yeah.
Then if you go to the emergency arbitrator, I actually tested once on ICC. It was not useful at all, and because emergency arbitrator took itself, of course, as Greg said, he need to hear from both. So it took us 15 days just to fix the hearing. And then we keep thinking, okay, yeah, the money won't be there. And in addition to that, if it's ICC, then you need to ratify it. Then it's actually no use. And I think that is something which is important for at least DEWA to see it and change it, even with the new rules, because they have an emergency arbitrator, but they need to change the executing mechanism quickly. So if they issue it, then the center should immediately has a right, like a court, to inform the bank not to do it. But we did test this also in the on the matters of the bond, which is on the airport in Abu Dhabi for freezing orders. I think the sensible way, as also Greg, he mentioned it clearly, that's the bank is not a party. So what you need to do is not a freezing, it's only to ask the tribunals to order the contractor or the employer to refrain from encash or applying for encashment. So you actually ordering the other party in the procedure not to do some actions. Okay, and actually on that matters we did succeed on that, and unfortunately then it has been nullified, that decision. But to be honest and fair with the other party, they did not encash it, because as also Greg said, is clearly they put a regards to the tribunal decision, because they will, if they did not listen to the orders, then they will face it definitely a tribunal to be more tougher to them on the futures, because the process is going on. So that is the best sensible way to ask for not to do or not to apply for encashment, because the bank is not a party, and plus mechanism, it will be very longer. Even if you got at that, then you need to go for ratifications. Then after ratification, you need to go to the court. By that time, the bond is gone. So that is the technicality problem on the arbitration, unfortunately.
Great. I'm conscious we've heard a lot from the lawyers recently, so just bringing Alfredo back into the picture. Mr. Ali picked up, I think probably 10 minutes or so ago, talked the word preparation. And one thing I just wanted to explore a bit more with you, Alfredo, is obviously we've talked about this is a really fast-moving process, often something you need to be doing in hours rather than days, and certainly not weeks. But from a contractor's perspective, if you do sense that there's going to be a call on the bond, what sort of steps are you practically taking to try and put yourself in the best possible position to defend that?
Well, I mean, the first step, as the heat increases between parties and we start to fear that, well, the other party may be seeking to enforce the bonds, the first thing we do is obviously, I mean, may seem obvious, but having heard my colleagues here, it gives more weight, is analyze your options. I mean, my colleagues have, yes, you can try to attach the bonds locally. You may have an option to seek an injunction under the emergency arbitration provisions if you have it, or in the course of a normal arbitration if you are already in arbitration. But you may have more options. I mean, it's not unusual, especially with international contractor, that you have your bonds back up with counter guarantees. So an option may be also to, let's say, depending on your perception of how much likely are you to succeed in local courts, to seek also protect your counter guarantees, so that the bank may be left calling your bond but with no money being received from your counter guarantees. So that would be the first step, to see, really put all your options on the table, try to rank them, which is the more and less likely to succeed in your circumstances, see what evidences you have to substantiate your case, because as Dr. Ali has spoken, it's all ultimately about, it's not more legal in terms of which legal arguments you need to use in your application, it's more what arguments you need to back up your application, what factual arguments and documents you have. And that will be the first step. Then once you have decided, or what you have seen, that one of the options may be seeking an attachment in local courts, the first thing is prepare for that. And obviously, again, it's obvious, but the next step will be find the local firm that is capable of doing a proper job for this. And this is essential for us, because we as international contractors are more used to engage or involve in our project international firms, and most of the firms are connected somehow, but maybe the firm you have chosen in a certain project, his local connection may not be the one you want to involve in this case. So second thing is make sure you have proper local advice from a tier 1 local firm. And again, we may use different local firms in our projects for different purposes, downstream, upstream, and so on. But in this case, our thing is we look for the firm that you are comfortable with and that has demonstrated experience in dealing with this type of application to make sure you don't mess the case. The next preparation thing, again, from our perspective of international contractor, is the power of attorney issue. And that's something you need to be well in advance, because you need to issue a power of attorney in favor of the firm who's going to represent you. So you need to have selected your firm beforehand. But especially in large corporation like my company, issuing a power of attorney may not be straightforward. As you said, you may have local directors in the country, but then the powers delegated to those directors may or may not be sufficient to go to the notary public in the UAE and issue a power of attorney in respect of your firm. And this is a tricky thing, especially in the UAE. There's a long story about awards being challenged on a lack of authority and so on. So make sure that you have, if you have directors, make sure they have proper power of attorney to issue power of attorney in respect of for litigation and similar circumstances, because otherwise you need to issue the power of attorney from your head office. You need to involve the legalization of this power of attorney, and that process itself may take overall some 2 to 3 weeks. You need to have original documents in English as a minimum. You do have, for example, in our case, since English is not our first language, we need to have bilingual power of attorney, legalize it and notarize it in our home country, send the original POAs to the UAE, translate it into Arabic, have that. So it's not a straightforward process. So it's definitely not something you can do the day you get the call on your bond, because the money will be out by the time you are able to appoint and empower your lawyers. So again, it requires some commercial anticipation as to when is the proper time. But whenever you feel there's an actual risk, you need to start preparing yourself, because being ready to file, leaving aside the application, drafting the application, can take you easily some 3 to 4 weeks, depending on how big is your company, how far are your internal procedures, and so on. And I think once you have all this in place, you just are ready to go. The last thing is make sure you try. I mean, we all know Dubai is a small community, and here people know each other. So try to keep the lower profile as possible, because if your client for any reason anticipates your move, you may be late again. So,
and Mr. Ali, what about you from your perspective? So you have a client like Alfredo coming to you, knocking on your door, saying to you, I think I've got this bond call, can you help me? What would you ideally like to see him or her come with them? You know, what would be in the bag in terms of preparation?
First of all, I wish all my clients like him. They make my life easy. Our life is easy, to be very frank. Me and Greg, the CMS team, always we pull our heads every hour. Here's what's going on. You need application tomorrow. How it's that? So what's Alfredo is actually said. It's what we wish that's happened, which is not happening, actually, with most of the contractor. And unless the international one, at least they are more ahead and everything. And that's by practice. I always keep saying this with my colleagues to our clients, always joint clients say, please, can we prepare a mile ahead? They might come. And the problem always a contractor, they think they can save that little bit on the cost. Because they are saying, yeah, we are good in negotiation. Don't worry, employer is listening to us. And we keep telling them the same sad stories. The clients will suddenly turn his face and then call the bond. Can you please make us the documents ready. Can you guys look at it from day one? I think Greg, he will talk about his sad stories more than me sometimes, because he's dealing with a lot of contractor and they always facing the same. But I think it's most important is, I always called it, it's like you need to have a ready food on the fridge. Okay, you just get it out whenever you feel that risk is coming and put it on microwave, heat it, submit it. Okay, you don't need to wait to prepare the documents, to translate, to put a strategy, because even the drafting the applications, everybody think that the drafting application is a standard application, but to be very frank, it's the law, maybe law part is it's a standard, the articles is a standard, but to explain on your applications, which is ex parte, you won't be able to explain to the judge, then you need really to demonstrate, you need to show the documents, you need to really get attention of the judge when you make application. And that's humanly cannot happen if you are asking me, I need this for 24 hours, because that is impossible to do it. And you have to put it in mind, today we are all online, we need to apply it on application online, then we need to, the judges not all the time is available, they have a hearings, so you need to push the application. Then after that, if you have that, then you need to go to execute it. So it's very tense process. And we keep saying, make it ready. That cost, you can implement it in your cost to preparation and everything. It won't be a major, but really it will be making a difference if you are ahead of the thinking of the employers of encashing. So always you need to be ahead. And this is what usually we work with the clients and we prepare. And I think so this type of, we are sharing our experience with the contractor, especially because they are facing a lot of this, and we keep telling them, learn from the mistakes, learn from the practice, you need to be ahead, you need to prepare yourself. In some other matters, always we keep telling them, even if you think that there is a nice time between you and an employer, you have to know that's in all contract, and I haven't seen the nice contracting ending always without a little bit dispute here and there, but you need to know that you need to document lots of things. And there is a good company actually doing that, and there is a really bad company which they are doing nothing. That is the biggest issues we have it. And of course, CMS, I leave Greg to talk about his experience maybe.
Yeah, no, thank you. No, that's all in line with our experience, and I guess probably one thing we recommend contractors to do, and I mentioned, and Alfredo's mentioned the power of attorney, is take out that power of attorney right at the beginning of the project. And I hope you'll never have to use it, but have just a local advocate, power of attorney in favour of a local advocate, so if the time does come where a bond is called, it's sort of already there in place. But the sort of points Mr. Ali made in terms of preparation, that all applies equally to arbitration also. It's a very quick process. It's a real race against time. If an employer has called the bond, as I've mentioned there, there can sometimes only be 3 or 4 days between the bond being called and the money being released. So all of these things are equally similar when it comes to like applying for that emergency arbitrator or an interim order.
Yeah, and if I may add one final thing is if like in my case you are a non-Arab speaker, be ready to trust your lawyer, because when they send you the application in perfect Arab to review it based on the information you've given to him, there's no way. I mean, even though it comes with English translations, sometimes the way they express things in Arab and translate into English do not align. So just make sure at least the story seems quite okay. I mean, I may have written, but I'm sure the Arab is the right one. So that will be my final advice.
Yeah, and I think just kind of extending the practical point that whenever I've spoken to contractor clients, their apprehension about doing all of this preparation has been cost. And I think one point that's come out of this is that a lot of the cost is often, it's at the back end. So a lot of the preparation work can be done by the contractors themselves. 80-90%. I was trying to extend Mr. Ali's analogy and the ready meal, maybe all of the ingredients are within the contractor's domain, the documents, pulling together the documents, putting together the chronologies, all of that type of stuff, which is you need really early in the process, and is the time-consuming part, can be done by the contractor. It doesn't need to be done by the lawyer, so you can save some costs that way. Just conscious of time, and I promised that I'd leave some time for questions and answers. I was just going to try and wrap things up and involve all of the panel. So I was thinking of two questions. I think the first question is going to be to Mr. Ali and Greg, and it's going to be, well, we've heard a lot about arbitration. We're here for Arbitration Week. Really kind of what are the advantages and disadvantages, and any other points you want to make about trying to prevent calls on bonds using arbitral institutions in the UAE. And then I was going to ask Alfredo and Waeel whether there's any alternatives, from a more practical user perspective, is there an alternative to arbitration? So yeah. I don't know, Greg or Mr. Ali, whether you want to go first.
No, should I jump in? Yeah, I guess just sort of practically using an arbitral tribunal to stop a bond call in the UAE. I think that in my experience anywhere, at least in certain instances, I guess tribunals here for sort of large complex construction disputes, it's generally English QCs that are appointed to the tribunal, and in the position, and I guess they sort of come to the proceedings without normally sort of experience of, or at least a huge amount of experience of dealing with these kind of urgent applications in the context of bond calls. You may be lucky and have an arbitrator who has that experience, but I think it's probably fair to say generally that sort of body of experience is limited. So there probably can be, and I guess like the sort of flip side of, well, I guess the point of them being English QCs is they're coming with the sort of English law mindset where bond calls are I think it's fair to say, are harder to stop under English law than they are here in the UAE. So you're dealing with a tribunal with that sort of mindset, and I think what a lot of tribunals sort of tend to do is if they take the view that this is perhaps an issue for the local court because it's very sort of UAE procedural to do with the UAE banks, all that kind of thing. So they may be a bit reluctant, or maybe not reluctant, but maybe hesitant, I guess, to make the order and to make the order within the time frame that's needed. So I think there's probably a bit of a practical difficulty there, depending on your tribunal. Now, you might have a sort of civil law tribunal who's UAE qualified, Mr. Ali or someone like that, who will know exactly what needs done and the significance and the importance. But I think that's probably a practical disadvantage of arbitration.
Yeah, Greg, if I may add, I mean, thinking to your point, it's not just the fact that your tribunal may be by let's say English form lawyers or barristers. It's like if you go the arbitration route, you need to rely in the law governing your contract, which may be less favorable than UAE law towards attachment or injunction or protecting your bonds. As you say, it's not just that the guy sitting in front of you is from a UK background, is that you may have a contract under English law and your chances of succeeding in defending your bond under English law may be much lower than the UAE law or any other alternative local law that you may have.
You're right. Yeah. And this is what exactly Gregor was right. You have to watch who's the tribunals is formed from, whether it's all of them is common law or a civil law. It's always because a common law, they will look at the bond, they said, it's unconditional on call, right?
Sure.
So why you are coming and challenging that? So for the concept is different. Civil law or a civil background tribunals, they know because they have been involved, so they will apply the law. That is something which is important to take a decision of applying these type of interim in front of them. It is good because sometimes it's good to see they know the matters, they understand sometimes, but the problem, the speed, even if you succeed, then you need to ratify it. The disadvantage coming here of ratifications, that is practical issues, I think. So we face it in front of tribunals.
So we've heard, is there anything else saying?
No, so only I think the best way of actually still I like it is the DIFC style.
Okay.
Because that's the application is it's really good.
You get to speak to the judge.
And it's give you the chances to explain your application, support your application on discussion with the judge. He will ask you lots of tough questions, but that is good because as a lawyer, its application itself is not only enough. It doesn't speak of your client's position. You need to have it. I think so. I wish the centers and change it, the style of emergency arbitrator to make it on immediate. So like the DIFC, I think, which I see it's a very sensible way to do it in a even better than Dubai courts. When you have an application, ask the party, and actually they call the both parties sometimes.
Yeah.
Okay, but anyhow, the beginning they give you a chance actually to explain and then get the orders. The return date they will fix it for the other, but at least you will be sure that the application has been heard in a right way. You did the best to get your clients the rights or the what they wish, and at the same times it's balancing. They give a order for freezing, and then they give a return date to the other parties to come and if they are challenging. So it's given more of balancing actually.
That's great. So we've heard obviously a lot about arbitration and the way that can be used to prevent bonds, but Alfredo and Waeel, are there any other ways?
I mean, as I touched before, I mean, depending on your bonding structure, you will have recourses in other jurisdictions to protect counter guarantees. If you have counter guarantees backing up your funding bond, negotiating with the client doesn't guarantee that the bond will not be called, but you may be able. I mean, if the issue is a trust issue that the client is fear that by the time he needs to call the bond, you may be not be able to back up that bond, or you may be able to negotiate alternative solutions, such as instead of because the ultimate thing you want is that the client basically holds your money for no reason. So you may be able to negotiate some escrow account where you deposit all or part of the money that is needed by the client at a particular point, so that you don't fear that risk of getting the full amount of your bond called, so that yes, okay, you understand the client, yes, I'm late, but your exposure is limited to this, not the full bond, maybe half of the bond. So why don't I provide you the money into this escrow account, so that if you need it, you have liquidity, and at the same time, I still have, because it's not the same circumstance as a company to somehow agree voluntarily to deposit or to pay some money than your bank receiving in order to cash your bond. In terms of impacting business, is much preferred to say I volunteer to do this rather than my bank is increasing my risk profile and is charging me huge fees for the fact that I have got my bond cash. But really, we don't have any other recourse on this.
Waeel, anything to add to that?
Actually, to me, I think negotiation is the best way, actually, because, now, as my colleague, they mentioned that what are the advantages and disadvantages of the courts and arbitration. In the end, the negotiation is the best way, because here, just like the contractor will try to say that he's willing to finish the work at time, or to if there's a breach, he will it will not be repeated again, and maybe they reschedule, maybe they can do anything. So I think negotiation is the best way for me. Is the best, and also from our experience, we have a lot of cases just with the negotiation, and it's work up.
So Wael's already answered my final question, but before I ask the other three too, can I just have an indication from the audience about if anyone has any questions or wants to make any points? If you put your hands up, I can gauge the amount of points that are going to be made, and then okay, right, there's enough to get from them. So in one word answer from the panel, so I've got time for these people to raise questions or make points. What's the best option to stop a bond call? Greg?
I would say both at the same time.
Both being
arbitration and you're seeking an order from an arbitral tribunal and going into the local courts.
Mr. Ali?
Of course, court. With some reservation on the way. Okay. But it's of course, the court is faster.
I would say I've been more successful in court than in arbitration. But I've more, let's say, much more cases in court than in arbitration. So that may be an indication of.
Perfect. Right. The audience, who wants to go first? Should we start closest to home? Can you introduce yourself and make your question or raise your point?
So I'm Oliver Dupemois, I'm partner and deputy head of arbitration at Horizons. And maybe this is another option that you were just touching upon there. This talk has been mostly about performance bonds, which are on demand, as Mr. Ali said. Perhaps another way may be to move away from the on-demand nature of the bond and maybe even involve the engineer, because it's all about performance. And obviously they are the ones assessing performance. So what are your thoughts on that?
If I may start. If you, I mean, and again, this is my personal experience. I would rather negotiate with the employer than with any engineer in the in Dubai. So how this answered your question?
Well, I guess the alternative would be not necessarily negotiating with the engineer or leaving them to determine the bond call for reasons Alfredo alluded to. But the other option would be, say, to give it to a third party, a dispute board or something in a FIDIC contract, where the dispute board is making a decision about whether the bond call should be made or not. How would you feel about that? Slightly better or? I
mean, yeah, but the reality, and again, I know in some of the Expo projects, they introduced dispute board provisions, but in practical, they were non-binding. So, I mean, yeah, dispute board has that neutrality fact that the engineer is lacking, at least in the region. But if they are not binding, is pretty much. I wouldn't want to say waste of time, but in reality, it's a waste of time. You have an award, but you don't know what to do it. So yes, I do agree. In some of the regions where dispute boards were the way they were intended to do, to have interim binding measures, dispute board will be the way forward. But I think the Middle East has been lagging in the introduction of dispute boards as an industry standard for many years, and it may be that in this next wave of projects, they are now more open to introduce it. We as a contractor will appreciate it.
Okay. Next question. Sorry.
I'm Hussam Youssef, Senior Associate at Haranian Partners. Well, at the outset, I'd like to thank the panel for bringing this hot topic for everyone for discussion and talking about the advantages and disadvantages of the precautionary attachment. Mr. Ali, the UAE Civil Procedure Law states that you have to file your merit case within 8 days from your attachment being granted, and failing which the attachment will be automatically released. And from experience, most of the construction contracts in the dispute clause includes so many pre-filing proceedings like negotiations, discussion, sending notice, meeting between the COAs, etc. So having this in hand, and on the other hand, you're bounded by the duration stated by the UAE Civil Procedure Law. How do you think, or what do you think there is a way or another out of this did open end?
Sure.
How we can come over this?
Sure. First, as I said on my previous or beginning of this seminar, the bond call is not actually the civil law procedure or civil procedure law will not be applied for the bond call. It will be a commercial call. So the 8 days will not be applied. That is the difficulty is the people they are doing. A normal precautionary attachments, yes, you need the 8 days to do it. And I assume now we are go away from the bond. We are talking about the only precautionary attachments over assets, bank account, others. Yes, this difficulty is always we face it, because if it's a mandatory to go the steps prior lodging your substantive case, which is on the arbitration or in the court, we actually we do lawyer games. So as usual, You did work with us before, so you know how our game sometimes. So always what we do, we are forced actually to start it and to show the courts that we did start it. Now in arbitration, we apply it, the application or request for arbitration, and usually the request of arbitration take time. That is enough to satisfy that we did start it, okay? Now that application will be falling away afterwards because it's maybe premature, but that is as per the arbitration process, it take more time. So you need to get to the client a solution to protect them. What we call it could be a painkiller for a period. This is what we do. If we succeed, we go for that application, knowing that maybe that application will be a strike off after a period, but we always tell the clients, we make another application ready. If that is goes away, then you apply it again, because it's a matter of tactic, how long you need to keep your clients safe and their interest is safe. This is the difference, okay? So we know that's difficulties there. Mostly it's premature, we know that, but you need to be ready to drop it and apply it again, and then apply another attachments again. So this is how we usually do it.
More money for the lawyers.
Yeah.
I'll take 2 more questions. Perfect, thanks.
Hello, my name is Noor Radi. I'm from Hassan Radi and Associates Law Firm in Bahrain. Thank you, first of all, thank you to all the panelists for this interesting session. The question that I have is in relation to in an arbitration proceeding between the contractor and the employer, if obviously the bank for calling a bond, the bank is not a party to that, to these arbitration proceedings. My question is, do you think that bringing the bank as party to the arbitration agreement initially, is it first of all like a viable option? And secondly, is it could it be like beneficial in terms of having the arbitration award, if successful, enforceable directly against the bank, and that may reduce the time, to instead of going to the court as a second step? Thank you.
Yeah, so that, yeah, I've never actually seen that happen in practice. I guess whether the bank would be willing initially to become a party to an arbitration agreement in a construction contract, I suspect probably no, or if they were willing to, they would definitely be sort of pricing in the risk of that scenario into the bond call. So I think sort of commercially, I guess maybe it's Alfredo or Waeel has other sort of thoughts or views I've experienced, whether that's something that's happened at the beginning of the project, but I would imagine commercially the bank wouldn't want to do that. I guess though, if it did happen and the bank was a party to the arbitration agreement and the tribunal was appointed, yet in theory that the tribunal should have jurisdiction to issue an order against the bank, and it certainly would resolve one of the, I guess, the sort of key problem with arbitration in this context, being that the bank's not a party.
So I think so. That is the just to talk from a UAE law. It's very, and it's also international. If the bank is not a party to the contract where there is an arbitration, they are not a party. So you cannot just bring them, and no tribunals, they will accept them to be a parties. Even sometimes the centers, they will try to say, yeah, but what is the arbitration agreement with these guys? That is the issues. We do this in the court. And even the court now, the registrar asking us what is the reason you guys bringing the bank to the application? We do it for a different reason sometimes. A tactic to get jurisdiction. So we bring the banks. So we know that it's a project in Abu Dhabi, but we need to bring it to Dubai court. So we bring the banks, which is in Dubai, who's issued the bonds. So we bring it to the Dubai one. But usually today, and in all time it used to accept it, but now the court saying, well, the bank is actually will be the instructed party if we accept it. They are not a parties to this application.
So you've never seen a case where the bank is party to the arbitration agreement itself?
I did not actually. Maybe Adrian or Greggy, if you guys noticed this before, but I haven't seen it because usually the bank, they have a relation only, especially the bank who actually issue the bond. Usually they have only a contract between them and the contractor because they issue a bond for them. Okay, but nothing else. It's the employer always not a parties. You can't. I didn't see it actually, to be perfect.
And I guess there's generally with bonds, it's maybe not always just one bank. There could be different banks or behind each bond and counter guarantees and all that sort of thing.
Yeah, I do agree. I mean, I haven't faced circumstances like that. What I have faced is situations, as I said, where in a scheme where you have a fronting bond and you have counter guarantees and you have been unable to defend the fronting bond, but you have been able to defend your counter guarantee, then dispute between the two banks. I mean, disputes between the bank who provided the fronting bond and paid, and the bank who provided the counter guarantee and doesn't pay. And I would say, in my experience, it is a normal practice that you're arranging with your bank. I mean, your main bank is the one that provided the counter guarantee for you. It's where you have the commercial relationship. So as part of this agreement, you need to, let's say, indemnify and defend the bank in this proceeding. So ultimately, if the banks fight against themselves, you are, let's say, behind the scenes defending that application because it was your bank who, let's say, succeeded in defending their.
So I think so. One thing that's good to, since this question, it's not directly, but it says one of the kinds happen now, and especially in the last period where, unfortunately, we see a lot of construction companies going to the insolvency. I did experience one matter where the bank actually who issued the bond, they know that their client is actually insolvent now. So what they did, because the bond is on demand, on call, there is no unconditional, there is no reason for them not to refuse it. So I don't know whether that's clever or not clever, but I can see it's clever just to delay it, but legally will not work. But the bank themselves, they file an arbitration against the employer, saying you are calling the bond, which is, we know from our clients that it is unjustified because the amount which you are calling the full bond, actually, we know that you are only maybe entitled for 20% of that. So your guys actually unjustifiable abusing your right for a call. And we are, as a bank, we see it that because we are paying, this is not justified. Now, legally, there is a big issues here because you already issue a bond on demand and you have no contractual relation with the employer. So you can't now just to say, oh, I know my client is bankrupt now, I'm at the high risk, because you have to take your securities, right? But that is one of the kind happened now in the past, actually this year, actually, which was for me is very weird, a new one, but it could be a good way because it's a way they haven't encash it. They find a justification for themselves not to cash that and pay to the employer, and they win at least for a year not to pay that. At the end, the tribunal, they said, you are absolutely wrong, you have no ground, you have to pay, but it's 1 year, and it's actually practical also. And Greg and Adrian, because you guys deal with a lot of construction, so it is sometimes a problem for the banks today, because a lots of bonds has been issued in the market, and sometimes the bank, they are not great on taking all securities, and especially if the bank, the company is very large, lots of business, they try to be a little bit lenient. This is the problem also the bank they are actually facing. But as you said, this is a new kind, or only one time I saw this one.
We're doing so well for time, but there's there's obviously a lot concerning to these issues.
We have
On the
to-
basis that no one's packing up their bags so far, I'm going to keep the questions going. But if you do need to leave, please do. There's the next one there, and then we'll go to the other side.
Yes, thank you all, gentlemen. Very interesting issues that I don't think we've got time really to unpack today. Sorry, my name's Paul Aston. I've spent most of my career as a partner with Holman Fenwick, mainly in the Singapore office where I'm based. And in April of this year, I moved over to join some friends in a local law firm, Asia Legal, which I'm really enjoying, being out of the big firm game. It's a great pleasure to be here. I deal obviously in the disputes arbitration space. My own experience of construction is mainly offshore and shipbuilding, although I have done land-based construction. I started off just wanting to ask a simple question. Did you have any confidence in ArbMed arbitration clauses? Because to me, I've always thought them to be a win-win, and they might provide a solution here in encouraging the parties to actually mediate. The gentleman over here quite rightly raised the multi-tiered arbitration clauses that we get. But of course, merely because you breach the arbitration clause will not be a defense when somebody just makes a call on a performance bond, but it might give you a claim, presumably, for breach of the arbitration clause. So I'll be interested in your comments on that. I'm also aware that culturally in various jurisdictions, mediation is regarded as either a very good thing, which as an accredited CEDAR mediator, I hold that view very much. But I'm aware that in many jurisdictions, cultures, lawyers take the views that it's really pinko liberal and not very good. I don't take that view. The second point I wanted to raise is that the construction legal industry and the users have come in for a lot of criticism for using and abusing arbitration. Queen Mary's College London lists the criticisms, and my view is it's not the arbitrators or the tribunals. In my views, the users tend to be the abusers, and that's to a large extent lawyers who are under instructions either to delay or get on with it quickly. I've seen a really refreshing approach by the Singapore International Commercial Court to the determination of disputes. I can't really give specific examples. All I can say is a number of the points that you gentlemen have raised today would seem to me to make a good international commercial court the right choice because of the flexibility of procedures, either rough and dirty adjudication, typical arbitration, or the full memorials lot. And that's all decided by the judge at the first hearing. And judges can be very persuasive on parties and also forcing them to mediate. I use the word force, not literally, but persuading them to mediate. You have a very good international commercial court here. And I know it's got a lot of flexibility. It surprised me to learn there's something like 21 international commercial courts in the world, and they're looking at having reciprocal enforcement of their own judgments. So two things, therefore, gentlemen. First of all, do you have any confidence in the ArbMed, and why wouldn't you advise your clients to use it? Because, as I say, I think it's win-win. And secondly, do you think that international commercial courts, with their flexibility, the fact that you can have civil law judges, different judges, you can have different law cases before the courts, do you think they're going to threaten arbitration, traditional arbitration in the construction industry? Sorry, there's a lot there, but I mean, gentlemen, you brought these issues up.
That's another seminar.
That is abusing of asking questions.
Your challenge is to make the answer shorter than the question.
Quick answer, I guess, to the first question in terms of whether some form of, I guess, like mediation or applying the dispute resolution provisions within the contract to try and deal with the issue and dispute. I suspect it all really comes down to whether the willingness of the party calling the bond, if they are wanting to, I guess, put the bond on hold and enter into some kind of mediation or amicable settlement discussion over whether it should be called or not.
Just before we move on, Mr. Ali, any sort of very quick observations about mediation in terms of Middle Eastern culture?
Mediation is very simple. It doesn't work here because it's not binding. That's a question. The binding issues is the best, the main major issues. Even that, what you talk about it, it's not. If it's not binding, then you're actually wasting your time. That is the mediation problem. Now the government, they try to put a lots of efforts now to put a mediation and make it binding. But as long as there is no binding, I don't see it's waste. It is worth to spend time and everything and try to, because you go and repeat it again on the arbitration or in the court.
Okay, sorry, Greg. Oh no, that's okay. But yes, I guess it all comes down to the willingness of the employer to enter into that process, and I think the points that Waeel and Alfredo mentioned earlier on, I think by the time you're at a point where a bond is being called, that's all been done. All these negotiations have happened. The parties are really at kind of the breaking point, I guess. So I suspect in the context of a bond call, well, yeah, in theory, it's a good idea. It probably wouldn't really happen commercially. I think things are quite drastic by the time bonds are being called.
Taking especially to your second point, I think the first question has been answered, and I agree with my colleagues that alternative dispute resolution, if they are not enforceable or they are not binding, it's just delaying the final result. At least in some jurisdictions, as I said, Southeast Asia, which I work also, they are much more keen and much more aligned with the spirit, and it works. But unfortunately, in this region, it doesn't. Going to your second point, from a contractor point of view, all we're looking for is first, cost effectiveness of the process, and second, time effectiveness of the process. And I do agree with you that arbitration is against both of these, is both expensive and lengthy, but unfortunately, it provides a certainty, which is something that courts does not necessarily provide in all jurisdictions we operate. For example, not only in Spain, where it's our headquarters, but in some other regions like UK or North America, we have no issues accepting local courts as dispute resolution means, because in many cases they are just more cost effective, they are cheaper and faster. It's not always the case, and we balance, and unfortunately the less worse in most cases is arbitration. When you just negotiate the project from scratch, depending with your project. For example, here in the Middle East, we avoid local courts at all means, not because the courts are not trustable, because unfortunately, when you operate or when you contact with the government or with government entities, as a contractor, you have the feeling that you are in a less favorable position, because again, here, if we litigate in local courts, where all the proceedings are in Arabic, and most of our staff are non-Arab speakers, how we can be, let's say, comfortable with the situation.
But now I don't.
I'm just taking the approach from my international background.
Before diplomatic relations deteriorate, maybe there's a perception point, and I think we'll probably take answering the rest of the question offline if that's okay. Just there was one right at the back, and if we could take that, and then I'll look at the bag packing.
My name is Saad, partner in Al Utaibi. Thanks the panel for the valuable note, and I always enjoy listening to Ali tactics and tricks. Basically, my comment rather than a question is about the culture we have in the construction industry and the bond. And I agree with Ali, you should get your food ready in the fridge and serve it. And this starts actually from the negotiation phase of the contract. So I blame the employer to be running after the bond from day one, and the contractor not doing well in negotiation the contract to get it to reach, let's say, to mitigate the risk for the bond. So few comment on how to mitigate the bond risk. I will start with, I think our colleague there mentioned about having the bond having the engineer decision before encashing the bond. So like this, you put a third party. Now we know he's gonna act in his independent head, but it's a one level, at least the consultant that could be liable for issuing a wrong notice. Second, you may link the encashment of the performance bond subject not to have available retention cash, because you know when you go ahead, so by the end of the project you may have 10% of the retention money available and you have the bond. So why you have to go to the bond and damage my financial position, and you still have the cash? So we can sort of convert or prevent the employer to encash the bond if the retention money is enough to cover the damages. So this could be, and that, but as I said, this have to start from the negotiation phase. And also you can negotiate the bond, because if you look at the contract in totality, you will have 10% advance bond, 10% for the performance bond, and 10% retention. So you have 30% bond. Why you need all of this? So if you negotiate it well in the beginning, the maximum bond I can give is 15%, which is enough. Like this, you will reduce the risk, or you mitigate the risk of performance bond. I'm talking about now the mechanism. Also, you can add one more thing, if I may, is before encashing the bond, requirement of a notice or an engagement for discussion for this specific topic of 1 week or 10 days. It will give you the leverage to discuss it with your lawyer, get yourself ready with your document translation, pleading. At least you know 1 day in advance if it's going to fail, you can go to the court. So these are things you can mitigate, or a solution to prevent the bond encashment.
Sure.
That's it.
Any
Thank
quick
you. Thank you very much.
Quick one. And I think that the difficulty I see with your point is some of our contracts already have these provisions, but there's a disconnection between the wording of the bond. I mean, the bond itself as a contract, where the employer wants fully unconditional document, and then the provisions of the contract that will allow the employer to pursue your bond. And there's complete disconnection. I mean, you negotiate the contract provisions, and you may add your provision that, yes, you need the engineer to determine, you need before the employer is able to do. But notwithstanding these provisions, if the employer goes to the bank with the unconditional paper, he will get the money. And then in a separate proceeding, as part of your larger dispute, you can then charge you if that call on the bond was contractual and not contractual. But in my experience, no employer will accept getting specific provisions into the bond itself, such as engineer, and I'm talking from a contractor, maybe my colleague.
I don't think any accepts it.
The bond is always unconditional.
Yeah.
Satisfaction of the employee, but the contractual to encash this unconditional bond, you can put some steps and measures. The idea is you have to turn this bond as an expensive loan for the employer, so he will think twice before he encash it. Because as you said, if you encash it, you encash it. But the idea I want to turn it that if you encash it today 1 million, after 2 years I'll get it 1.2.
Yeah, and I think
this is the main idea. So at least the employer will think twice before they.
no, you're right, and I think that's the reason why the trend, as I said at the beginning of the talk, has changed from casting the bond as a leverage tool to being more reasonable, because there may have been many past instances where cash bond have had to be returned to contractors with interest after the dispute proceedings.
Yes, right, last very quick question. Just stand here, please.
Thank you. Rodrigo Carrera, Horizons. If I follow up from the previous question from the gentleman, this competition between international commercial courts and arbitration, I do a lot of DXC litigation here. I appear before the court. And, if you go back to, when we all did a course in arbitration 101, what are the advantages of arbitration? Speed, confidentiality, expertise of the arbitrators. Now, you compare this with commercial courts, the judges, the commercial courts are very experienced. It can be very quick. It can be efficient. What is the real difference? Confidentiality. Because proceedings in court are not, can be confidential, but the judgment will not be confidential. Whereas arbitral awards, unless and until they're enforced in court, they will be kept away from the public. So then that follows a question for Waeel and for Alfredo. How valuable is confidentiality for you in selecting the mode of dispute resolution?
Before that, what about the fees? It's a big difference from arbitration to the cost.
The cost.
Yeah, the cost of the arbitration is just
And he's the government saying it.
compare it with the court.
Yeah, but eventually.
So guys, can we just answer?
Yeah.
I'm just really
Okay,
conscious of
so,
time.
yes.
So.
So about the confidentiality, you're talking about just, can you specify your question again,
The
please?
idea that the dispute will be just private will be just you and the contractor.
How important is
and the public
confidentiality?
will not
in
know
process?
that there is a dispute.
It's sure, just like confidentiality is very important thing, but just also you have to see other elements also, as I told you, just like, for example, for the arbitration, there is some advantage, one of them, the confidentiality, okay? And, but also you have also to see this, like for the court, just like you have like 3 stages, okay? And arbitration is only one. And in the end, you need to ratify the judgment, and then also maybe the other issues. So you have also on the some arbitration, just like tribunals, will be not only lawyers, some engineers and like this. So they will not be all aware about this, the legal points and like this, even in interpretation of the contract. So the court will be just like the best, is what I think. So for confidentiality, sometimes also in the law, and Mr. Ali can just explain this more than me, that also in certain cases, if it's sensitive, you can ask the court also to be the, like the procedure to be as confidential. This is a special request. Is what I think.
In my experience, although confidentiality is again a deciding factor, it's not the deciding factor. As I insist, it will be more the certainness or the how much we trust or how mature the local system is for us as foreigners to rely on it. Or what is the perception? I mean, I'm not saying that it's not about how robust it is, how we perceive it as foreigners, and time efficiency and cost. This is our main driver. So first, if we believe it's robust and it's more time efficient and cheaper, we don't care. But confidentiality will be there, but not the one forcing our decision.
Thank you.
I think there's also a good argument for saying arbitration isn't as confidential as it used to be, but that's probably a subject of a separate discussion. Like any good construction project, we've overrun significantly. But finally,
without claims.
I'd like to first of all thank the speakers, Waeel, Alfredo, Ali, and Greg. If we could thank them in the traditional way. Rally to close the seminar.
First of all, I'm really glad to have for a second year a joint panelist from CMS. We always enjoy working with them, and we enjoy also having them on their experience to be with us. This year we have Alfredo and Waeel, and it's really good. Thanks for all the audience to come today. I hope we were trying not to be except practical for you guys. We try to come out of the box a little bit, try to not to be just on the same as maybe other events you hear at the same word, but thank you for your time. Thank you for coming here and efforts to come early morning. And I wish we'll be in touch, and all panelists actually ready for any questions. If you guys have it, you have our contact, you can come to us, and thank you very much for this. Thank you.
Thank you.